right, wow, I guess you can hear me. All right. So thanks for the invitation to come back. I appreciate this very much. I want to start with a little background, actually. So one is a caveat. The PowerPoint you're about to see is prepared by me, and I'm volunteering to come down. I had sort of precious little time to work everything through. If there are errors or mistakes, let's just pretend they're not there. I got one of the reviews from last time said there is a typo on such and such a slide, and I thought, well, okay, that's true, but we'll soldier on somehow. Focus on content; it's the principle. So the second thing I wanted to say is sort of why I'm here and why I really like volunteering for this, which is simply I really believe in public service. I grew up in Washington. I'm from Spokane. I went to the Evergreen State College. I teach at the University of Washington. My family has served the state in different jobs and capacities, and I have also. I've worked with the Attorney General's office, worked with our state Supreme Courts. I've really liked teaching. I believe very much in sort of doing the work of the people, by the people, for the people. And I think I share that with everybody in this room. I think when people become hearing officers or ALJs, there's a huge need for people to, at least if not have transparency, at least understand how decisions are being made and why they're being made. And for a lot of our citizens, you're really the first authority that they come across that has decision-making power over them. Most people do not go through the criminal system, so they don't get to see judges in that way. But hearing officers and ALJs, they do get to see you. And historically, there's something unique about you. I mentioned it last time, but I want to frame it with this. And that's initially in the legal history of the country, in the formation of the different branches of government under the Constitution. They never saw administrative law judges coming. It just was not on their radar at the time. The legislature, with its lawmaking powers, delegates authority over to the chief executive, right? And then the chief executive begins the administration of everything that happens there. And under that administration then arises, for the departments and agencies, the need to have hearing officers and ALJs. What happened is, historically, in the sort of post-World War II era, this is when we really see, or at least sort of Franklin D. Roosevelt and beyond, this is where we see the emergence structurally of people in your sorts of positions. During the 20th century, it grew and grew, but in the 21st century, you are the fastest growing portion of decision makers. And your decision makers like Article 3 judiciary, right? But you're authorized by the legislature and you're then implemented by the executive branch. You are a combination of all three branches of government. And in the balance of powers, they didn't provide for that kind of combination, right? But you have emerged, you've developed and evolved in that way. And now it's absolutely necessary to have every person in this room. And as decades go by, there will be more and more of hearing officers and ALJs because ordinances, regulations, right, the implementations of public policies and laws require your intervention, right? You are that moment where the government and the people touch each other. So I'm very happy to be able to talk to you about what it is that you do, because I think as constitutional creatures go, you are a marvelous and rare one, right? And certainly one that was unexpected, but good unexpected things happen. So we'll begin there. All right. There are certainly a number of overlapping things for administrative decisions. So I try and provide a graphic when I can to sort of visually make the point. But here you've got things controlling your decision. So one question I have is that who are the new people to hearings and ALJ work? Who are the new folks in the room? Okay. So there's maybe about a dozen of us. Is that all right? And then who are sort of mid-level folks? We've been at it for a while, sort of less than 10 years. All right, that's about half the room. All right, and then who are our seasoned, experienced folks with sort of more than 10 years? All right, so I'm going to try and sort of speak to each grouping of folks here. So for the new people, I'd like to just keep this image in mind. If you've been at it for a while, this is sort of a refresher. if you really, really know what you're doing, you might have a different way of thinking about this. And if so, I would actually like to hear your thoughts on it. But one of the first requirements on your decisions are the statutory and common law requirements. All right, now the state has a whole number of statutory requirements that you comply with. And I am just going to assume that your training has been impeccable around what those statutes might be. And there is some interaction at the federal level as well. Right, now one of the main reasons, and I'm not sure if in people's trainings they think about this very much, but one of the reasons the federal level for administrative law is important to us is actually through the 14th Amendment. All right, so the 14th Amendment is the post-Civil War amendment. It begins by making us dual citizens, right? We're citizens of the United States and we're citizens of the state in which we reside. The sort of first section of the 14th Amendment is what gives us the Due Process Clause and the Equal Protection Clause. The Due Process Clause, right, is you shall not be deprived of life, liberty, or property without the due process of law. And it gets split in two, right, with 200 years of jurisprudence, right, or 150 after that. We basically say there's procedural due process and there's substantive due process. Sometimes it's hard to see the distinction between the two. But procedural due process is where the Administrative Procedure Act comes from. It is literally an articulation of the Due Process Clause from the 14th Amendment at the federal or at the state level. All right, state constitutions have similar provisions. That's the justification for them. Because of that, we navigate in constitutional waters. So it may look very technical and specific what you're doing, but what you're also doing is articulating constitutional provisions. All right, the next sort of piece of the puzzle here I'd like us to pay attention to is the idea of a reviewing court. All right, so when I was clerking for Justice Johnson, I had not unique to me, unique to any clerk really, experience of seeing how judicial politics worked inside the court system. And one of the things that we'll notice on appellate decisions is there's always an authoring judge. There's a chamber who gets to author the decision. That authoring chamber tends to be pre-assigned, right? A case will go to a given judge to sort of prepare the pre-hearing memo for the court. The court will vote. The person who's sort of leading with the majority opinion gets to be the authoring judge at that time. But that opinion is never just what that judge wants to say. You have to get the other judges to sign on to the decision, right? And so a huge editorial dance begins to try and get a decision out. But one thing I learned very quickly, judges do not like their decisions taken away from them. They don't want to lose the majority. I think there's a little professional honor involved in this. There's a little bit of pride involved in what that might be. But this is the same for any decision maker. When we put in the time and the effort to work with the parties, to work with the record, to have our hearings, to write and draft and issue the decision, we would like it to stand, right? We like stare decisis. It's a nice principle in a common law system. So one of the things that's, I think, important when you're thinking about writing your administrative decisions is to know where it goes if something goes wrong and how to prepare in advance for the tightest, most competent and defensible decision you can make, right? And so the reviewing courts, how they look at administrative decisions becomes very important in how you draft an administrative decision. All right, the third piece of the puzzle is actually levels of institutional deference. Now, this is arising from, and I think you can see it in my opening remarks, the way the whole structure of government is set up with the delegation of powers. So when the delegation of authority actually moves from the legislature to the executive branch, and from the executive branch into the departments and agencies, there are specialties, right? There are special skills that each department can bring to the table. And those special skills and abilities give you kind of an expertise that regular judges in the court system who are generalists will not have, right? They just don't know it. You become the best positioned person to think about and weigh and balance the rules or regulations and the facts that are before you. So with that as an idea, there comes a certain deference to you. Now, I think, well, I'll simply ask you this. And I'll try not to make this very odd, but the standards of review. Often when we're in law school or we're doing CLEs or things like that, there's confusions about what a standard of review is. And I'll just ask you, in your understanding, what is a standard of review? What is a standard of review? And any answer will do. Off the top of your head, what's your current understanding? What's a standard of review? Thinking, no one, so you're among friends here. And actually, the camera is only focused on me, they can't see you. Yeah, all right, de novo is a standard of review, all right? And the de novo is one of those great Latin phrases, right? Where the reviewing court looks at it completely new. Right, and then what's the opposite end of that spectrum? Yeah, abuse of discretion. All right, now that's one that you might be familiar with, right? So abuse of discretion, that happens when you've got usually factual matters that are in question, right? So that since the decision maker at the lowest level is the one best positioned to decide how it's going on, unless there's no evidence, right, or unless the evidence is just super, super weak, they will defer to you, right? They will defer to you. So one of the things I want you to think about is that a standard of review is actually not what most people call it. They think it's the lens through which the appellate court reviews the lower court decision. It's not the lens. It's the level of deference they give to the decision maker. It's the level of deference. So de novo is no deference. It does not matter what you did at the lower level. The abuse of discretion is great deference, right? There really has to be a problem with the record before they will touch it. And so that level of deference makes a difference to us. The nice thing is that we have built into the administrative process, when it's being reviewed by a court of law, a set of deferential standards, right, that they will use. It's good to be aware of them, or at least some of the subtleties of them. The next thing is drafting the decision itself. So I think one of the most interesting things about decision writing is I first learned about as I was teaching and working in international commercial arbitration and meeting people from around the world and seeing what different legal systems looked like, seeing how people were arguing things, what their briefing was like, what official decisions were, what informal decisions were. And a number of structures jumped out at me because I'd been teaching and working as an attorney for a while. And the structure of a decision, right, the form, is actually very, very strong in content, which is to say the form of what we write, the structure that we use, is the only vehicle we have to deliver our ideas and the actual content of what we're doing. So form and content for us are almost indistinguishable. Now this is not true in other areas, all right? It's not true in other areas, but for law, form and content is very, very important. So the way you draft a decision, right, will make a big difference in how the public or a citizen or a court will encounter your decision-making process. The last thing is style, all right, which is it's not so much how we're structuring something, it's the word choice, it's the tone, it's the mood that you're using, and we'll talk about that a bit today. So I'll be going through these sort of 5 interlocking rings. And let me pause there for a second. Any questions on this? Any questions on this? No? All right. I have bad eyesight, but raptor-like vision for small hand movements. So which can be mistaken because of the bad vision part. So sometimes if you scratch your eye, I think you're asking a question. So if I do that, forgive me. All right, so let's try. All right, so here's what due process is requiring in Washington. I think most of us should have seen this at some point. I've highlighted in red the things I want folks to pay attention to. So initial and final order shall include a statement of findings and conclusions and the reasons and basis therefore, on all the material issues of fact, law, or discretion presented on the record, including the remedy or sanction, and if applicable, the action taken on a petition for a stay of effectiveness. And we jump down a little ways. The order shall also include a statement of the available procedures and time limits for seeking reconsideration or other administrative relief.
And it will also include a statement of any circumstances under which the initial order, without further notice, may become a final order. All right, what I want to say here is what you're being instructed to do by statute is very, very similar to sort of a Miranda warning. All right, especially at the end. So we didn't always have Miranda rights in the United States. There was a Supreme Court case, and voila, we got Miranda rights. But what it does, effectively, is it gives people notice of what the rights happen to be. And it informs you the consequences of what happened if you waive your rights, right? So the right to remain silent, right? If you waive this right, which you say can or may be used against you in a court of law, right? So now you know the consequence, you're informed of the right. You're doing this at the end of the decision, right? You're actually showing them what the procedural due process of their case is going to be, all right? And they may not know it. They may have absolutely no idea how any of this works. The longer we do any job, the more comfortable we are in any process. Like the longer we work for the courts or for the Office of Administrative Hearings or any of the agencies, the more accustomed we are to the nuances, the technicalities, the process, we begin to take them for granted a little bit and forget to see it through the eyes of someone who's never seen the system before, who's never encountered it before. And so that is there actually for that new vision, for the people who are new to it. And it's there as a reminder for other people. The first part of it, though, is actually, this is really the main content of your decision. And this content is actually shared, fascinatingly, by most legal systems around the world. When they announce a decision, they want to know briefly what the key reasons supporting the decision are. You can't just give somebody an outcome. They want to see what the justification for the outcome happens to be. And this is what gets built into this statutory directive. All right, when we look at judicial review in the state of Washington, these are the sorts of factors that they're looking at. All right, so from the court's point of view, this is what enables them to either affirm or change your decision. Right? This is what they're looking for. From our point of view, these are the things we want to think about when we're drafting, all right, for what a court might do when we're actually looking at your work. So the violation of a constitutional provision, so it can be either facially or applied. So now I'm going to just make sure we're all on the same page. Do you remember the difference between a facial challenge and an as-applied challenge? What is a facial challenge? What is a facial challenge? This is good. Again, this is the low risk environment.
It's always unconstitutional.
This is
whatever it is, it's always unconstitutional. It's not something that's dependent on the facts. It's on its plain face. It's just always unconstitutional.
Yeah.
It
Okay.
violates the plain language of the law.
There we are. All right. It's always unconstitutional. It doesn't matter what the fact pattern it's being applied to happens to be. It's always. Now you used on its face. Facially is on its face. What does that actually tell us to look at? The language. We're just looking at the words, right? So a facial challenge means the words as written, right, have a problem, a defect with the constitutionality of what's written there. All right. There are plenty in the history of administrative law of regulations and ordinances that on their face are problematic, all right, that just in the words that are used, they're problematic. All right, but we also rapidly realize under the law that things that are written in a more neutral way can be problematic when they actually apply to a specific fact pattern. Right, now I think, at the national level, executive orders, right, executive orders are deeply in the administrative state. Right? And those executive orders, that language matters. And we can see sometimes that some language in executive orders is able to be facially challenged, right, as violating the Constitution. Other times it's revised or written to be more neutral, but then as it's applied, right, it violates various constitutional provisions. So if that's the case, then your decision is vulnerable, right, to judicial review and reversal. Right. The second one is the exceeding authority, either statutory or jurisdictional authority. This is difficult and confusing. So, actually, Dharma and I were just talking before I came in
about Washington's very interesting dynamic around administrative law right now. And this is part of a historical dynamic as well. And the dynamic is this: do you centralize and consolidate, or do you decentralize and send it out to all the agencies and departments? How do you handle decision-making authority? Of course, when you centralize, it becomes very, very efficient. But what you lose is technical expertise and subtlety and the ability to vary the application of what's happening, case to case to case, right? And the ability to perceive the nuances of whether a rule is broad or narrow and how it should be broad or narrow, right? So if you centralize, that's what's at risk. But that becomes kind of expensive. 20 years later, everybody wants to consolidate at that point. 20 years after that, they want to decentralize again. All right, so you're subject to basically a governmental yo-yo, right? And this is not your fault. This is sort of at the lawmaker organization or governor's office side of things. But gubernatorial decisions, right, affect us in how we're organized. If you have a centralized group who's making all the decisions, there is the possibility of people not realizing what their jurisdictional authority happens to be, or what the statute actually covers. When you're deeply embedded in a department or an agency, you're very aware, right, of what is covered by your statutes and your rules and your regulations. So it's something that can be handled by a transition team, but it's an issue, and it can create a weakness or a defect in our decisions. And if that's there, then that's subject to judicial review, and that can cause a problem for us. All right, a procedural defect is the next thing that the courts can look for. And procedural defects can come in a lot of different varieties. I'm curious, I am actually very, very curious, what procedural defects have you guys encountered? What sorts of things have you encountered as a procedural defect?
Ineffective notice.
Yeah,
Ineffective notice.
All right, ineffective notice. That's excellent. All right, this is a standard problem. All right, how do you make sure somebody has notice? So at the University of Washington, for instance, I'm the chair of the Faculty Appeals Board. So I do administrative judging, right, for student discipline. That's part of my job. The hearing officers and the AAGs sort of have arrived at the idea that students at the University of Washington can receive proper notice if you send them an email to their university email account. Okay, that is sufficient notice, all right? And furthermore, there's no follow-up. They don't check it. They don't see whether it's been opened. They don't know whether it's gone into a spam filter. They don't know anything about it. Under the sort of auspices that if they become a student, they've sort of agreed that this is their official method of contact. And we don't have to use their address or their telephone number because that could compromise the privacy of the student if you send a notice and their family receives it or their roommates receive it. But if we're suspending them for a quarter or more, or we're dismissing them, or we're fining them a large amount of money, this is going to bring in due process concerns, right? They made me the chair because I'm an attorney and I teach civil procedure at the law school. So, and this was one of my first arguments where I looked at the AAG and I was like, you have got to be kidding me that you think that's sufficient notice. I said, no, this is the way we've been doing it. For how long? Since we've had email. Okay, this is not good, people. This is just not good. This is a procedural defect. Right, but here's the very interesting thing, in sort of the welcome to real-world politics. The question is, do you spend the administrative resources to provide a robust best practices notice, or do you just go with what is very, very efficient administratively and allow people to take you to court if they have a real problem with what's happening? And since court is so expensive, right, this is roughly, you're looking at about a minimum of $25,000 these days to get in on a challenge at all at the trial court level as a reviewing appellate court. Most of the administrative sort of punishments will not be deemed to rise to the level to merit that. So you have to have somebody who's very principled and very well funded. And in terms of risk management, you can see that the check and balances deal with the few court cases that arise and then just carry on with the rest of it. I think this is bad risk management. I don't think that makes any sense. And I don't think our agencies and departments work that way. We strive for a higher standard. All right, that standard is a procedural due process standard. All right, errors of law. All right, so errors of law are
are very interesting because sometimes we don't know them when we're making them, right? They're determined long after the fact. So it's hard to defend against this one a little bit, but we try and prepare. So the nice thing is that in an adversarial system, at least the people who are sort of prosecuting the problem are aware of the relevant legal authority and will help provide it to us. But we are dealing with an incredible variety and diversity of sort of defendants, right? With all kinds, sometimes they have lawyers, sometimes they don't. Most of the times they don't, they're pro se. Sometimes they're experienced pro se people. Sometimes they're incredibly contentious and love litigation, and they like to fight the state, fight the power in any way imaginable, not realizing that the power is actually there helping most people, right? And then there are other people who are just, it's a one-off for them. They didn't realize that there was going to be a problem until they received a notice, and then there's hearings, and they're kind of brought into it that way. They're a bit like deer in headlights, right? And so you'll find ALJs have a lot of different demeanors, right? Hearings officers have a lot of different demeanors. We try to be neutral. And if they're really not understanding what's happening, we try and explain what's going on to them. We give a lot of latitude in terms of evidence, right? Things that will allow to come in, right? If you need more rope, have more rope, right? That sort of thing. And I think, you know, one of the nice things is that we're also able, we're trained legal professionals, so we can do independent legal research to make sure that we know, we can see if there's been any new cases, right? We can see if there's been any modifications. Excuse me, my throat is very dry. So we can see if there's been modifications at the statutory level, at the department level. We track, right, especially if we're in an agency, we track changes, excuse me. We track any changes that can happen, right? And that brings kind of an added safety level to what's occurring, right? There's a real problem. Perhaps errors of law to stick in my throat. All right. The next one here is something that is, I think, very difficult, which is not supported by substantial evidence. All right. I'm just going to ask you this. What is substantial evidence? What is your experience of what is substantial evidence?
What the court says it is.
When a court says it is. All right, this is again the after effect, oh, it was an error of law. All right, but what is your experience with substantial evidence? I mean, I'm sure we've all had cases where we thought, this is a weak case. There's some evidence in the record. It's kind of more likely than not that it happened, but there's just not a whole lot to go on here, right? And then your defendant comes out with information that is largely unverified. Oh, thank you very much. That is largely unverified, right? So it's hard to corroborate what they're saying. So we're not sure. Where in all of this mess is the substantial evidence? Have you had that sort of situation? All right, who has had that sort of situation? We should have almost all hands in the room should go up around this point. Yeah, absolutely. All right, and it gives us a bit of a fear, right? You don't want to make a wrong decision. You want your decision based, right, on an application of law to fact. So fact is very important. All right, the evidence, excuse me. Not sure where the fog is in my phone. Okay, the difficulty with substantial evidence in a lot of different ways is that it just depends on the case in front of you and what it looks like. And that means that the court system itself also does not know what substantial evidence is until they think they see what it's not. This is very similar to pornography. Right? This is with the Supreme Court's ruling. I'm not sure what pornography is, but I recognize it when I see it. All right? We're not sure what substantial evidence is, but we recognize it when we think it's not enough. Right? When we think we've missed it somehow. So some people will deal with this by really massaging the parties presenting in front of them to ask them questions. All right, now people have different styles as a decision maker. Some really are very, very quiet and let the parties do what it is they need to do.
Others are a little more directive. They'll ask questions when they think something is being missed, because you know you have to write the decision, so you need to connect all the dots. And if they haven't given it to you, you'll say, well, okay, so now I'm very interested in this, could you talk about that? Right, and see what they can do. All right, and these things are permissible from a neutral decision maker, right? You can ask questions. The substantial evidence, though, is something that you really need to lock down. All right, because it can be an utterly fatal defect, because it leads to a finding of a decision being, right, an abuse of discretion. It leads to a decision being found to be arbitrary and capricious. All right, these are phrases we don't like to hear, right, in the administrative law world. So evidence or having an evidence standard is there. One of the things about the evidence standard is that there are two standards, and sometimes I think maybe we merge them, or we don't break them into separate parts very effectively. The standards are this: there's a burden of proof and a burden of persuasion. All right, and these are evidentiary standards. All right, but they're two very, very different standards. So what's your understanding of what a burden of proof is? Or it's also called a burden of production. Right, burden of production, burden of persuasion. What's your understanding of burden of production?
Which party has the responsibility to come forward with evidence?
All right, so which party has the responsibility to come forward with evidence, but which is the sort of the burden of proof? The burden is on one party or the other party. Usually it's going to be on the government, right, to do that sort of thing. There are affirmative defenses, it switches to the other side. But the burden of production, though, is a more technical idea within this. What is the burden of production, or your understanding of the burden of production? It's related to substantial evidence. Thoughts or ideas? Yeah.
The quantity of evidence to prove your case?
Yeah, you can call it the quantity of evidence. You could also look at it as we just actually need evidence in the record, right? This is you've got to come forward with some amount of concrete evidence, all right? Sometimes evidence produces the ability to make inferences, right? And inferences are completely permissible, but you have to make inferences between two concrete things. All right, so you've got to get something concrete out there. If a party does not get something concrete out there, right, they're not meeting the burden of production. That's very difficult at that level. The burden of persuasion is different, though. What's the burden of persuasion? What's the burden of persuasion? We could actually go off of your comment. What was you said quantity.
Yeah, or the amount, that'd be like 51% or something.
All right, and then what would be the opposite or another factor? Yeah.
Would be the quality.
The quality of the evidence, right? The burden of persuasion is the quality of the evidence, right? So because one party has produced 51 emails and the other party produced 49 emails does not mean that they met their burden by the 51 emails. Right, the quality of the email is what's really going to determine this. All right, the fact that they put in emails is great. Our burden of production has been satisfied, but the burden of persuasion is now very important to us. How we weigh and balance what's there. So this issue is something that we should track. And if you don't sort of separate out our thinking on this, we can misstep in this area. So I think it's very important when we're dealing with people to make sure that we're thinking about both kinds of burdens. Right, both kinds of burdens that are there. Because especially defendants, they'll put in sometimes the most random assortment of evidence, right, for us to take a look at. And they're just not sure what's important in all of that. Our job is to figure out what is actually important in all of that. And when we're doing that, we're actually dealing a lot more with the burden of persuasion and seeing whether or not they've kind of made their case, or whether or not we can infer their case for them. Right, when they've done it, so that they've had their day in front of an officer to get a very cogent decision. All right, the sort of next weakness here is the failure to decide all the necessary issues. This also is super dependent on your case. All right, what are the necessary issues? Well, good golly, what's the violation being alleged, I guess, by the department or the agency? And then does that break down into subgroups? But what it requires us to do is to make sure that we're looking at it from all of the required perspectives, right? That we are making the decision where everything that needs to be there is there. Each violation is addressed. If a violation breaks down in component parts, we're addressing the component parts.
Even if we're raising and dismissing parts, this is not an issue of the case. We actually put it there so that we see that we are addressing everything that's happening. This is one of the things that insulates us from judicial reversal, right, or review, is if we're actually making sure we're hitting all of the rules that need to be answered, all the questions that need to be answered. If we don't do that, right, so, and here's where the misstep can happen. You get a complicated case with a lot of different issues, and based on our experience, we know that there's a dispositive issue. There's actually one issue that decides the whole thing, all right, and we answer that. But then we don't go into the minor ones that don't actually swing it one direction or the other. That actually allows for a vulnerability to exist, right, in your decision-making process. So although our experience tells us there is only one thing that matters there, the due process procedure says actually address all the matters, all right, all the matters that are necessary for full resolution. All right, so that's one of the pieces. The next one is basically, it's the disqualification issue. This is a conflict of interest, right? Just straight up, that's what this provision is addressing. The conflict of interest is interesting in a lot of different ways. So, and this is where a lot of people without legal experience can get very, very frustrated. So I'll put it to you like this. If you're in an employment law situation, and there's, so we're going to leave the admin world for a second and go back into the court world because we can see it very clearly there. If you're talking about discrimination based on gender, so somebody's saying they have a hostile work environment based on gender discrimination, and the decision maker, right, corresponds to the person making the complaint, there can rise a question about whether there's a conflict of interest, which is to say, if it's a female person complaining, can you have a female decision maker, right? Or is there going to be a conflict of interest? If in a racial situation, somebody corresponds to the person making the case, right? Does that create a conflict of interest? And our answer has been legally definitively no, absolutely not. This is, the decision maker is neutral. It does not matter what their race is, what their gender is, what their sex is, what their sexual orientation is. Right? We do not have that as a means to disqualify a decision maker. What we do have to disqualify a decision maker are material conflicts, all right? Sometimes relational conflicts, all right? Material conflicts, well, let me just ask you, what's your understanding of a material conflict of interest? What's a material conflict? What might that be?
Financial interest.
All right, a financial interest, all right, commonly stocks in something or you own something. Right, if you're part of an association, right, or part of a group, that can be a material kind of conflict. The relational conflicts would look like what? What would be a relational conflict of interest? This is, yeah.
You may represent a conflicting party.
Yeah, so you may be related to the party,
Related, yes.
right, or you know the representative. All right, now one question is, can you just know a representative, or how close does the relationship have to be? All right. Now, the legal field, right, is a closely known group of people. Right. We're part of bar associations. We go to law schools together. We do CLEs together. Right. We make presentations. We have our careers side by side. We interact with each other all the time. Right, and depending on your community, how large or small your community is, you know a lot of people to some degree, sometimes quite closely. So usually those sorts of relationships don't create a conflict of interest, right? Usually they don't. Family members will. That will almost automatically get you a conflict of interest. People who've married into your family, that gets you a conflict. The best friends, it's debatable. Depends on the jurisdiction, actually, how that works. What you want to do, and I think which is very, very interesting, is to preempt this sort of challenge to your ability to hear a case. Sometimes the challenge simply comes from prejudice, right, or bias of some sort. Or they think they just can't get a fair hearing based on who you are. All right, well, the law does not legislate based on who you are. It legislates based on what you do. Criminal law is not against people, it's against behavior. Right, it's the same sort of thing in this context. If you think that there is a colorable argument, it might be best to simply recuse yourself and turn it over to a different decision maker, if you think it's a colorable argument. What happens though is that generally speaking, if somebody asks for disqualification, you as the decision maker actually get to take the first crack at answering this, right? Whether you're going to hear the case in a neutral and objective way or not, all right? You get to answer that. Sometimes the different groupings have a way to handle it. It will go to the head of the department, right? Or it will go to the sort of a chief hearing officer or something like that to figure out whether there might be a conflict. For efficiency's sake, usually when something is assigned to you, we keep it assigned and we just move forward with that. But I think disqualification is it's an important area. And when you're dealing with the level of kind of social animosity that we're entering into now, that is similar to social animosity in the early 60s, ALJs are going to be on the receiving end of this. All right, you're going to be on the receiving end of this, and I think it's good at this point to at least raise this flag for us as a concern to take. All right, so, but it's one that you can be proactive about, right? You can gauge the situation. All right, the next thing here then is inconsistency with agency rules. So to some degree, this is a matter of interpretation. All right, if you've got expertise in your agency or department, you're going to really understand what's happening. Occasionally, you might have a difference of opinion on whether a rule is broad or narrow. If it's broad, it applies to more situations and more people. If it's narrow, it applies to fewer. Since we don't know what all of our other ALJs and hearing officers are doing most of the time because of the quantity of cases moving through, we can end up with some inconsistent interpretations of agency rules that we're unaware of. But thanks to public records disclosures, right, the person challenging might be able to figure out there's a discrepancy. One nice way of handling this sort of thing is in academics, we call them norming sessions or norming meetings. And it's not norm from Cheers, it's where we start to compare all the different decisions we've made on the same sorts of rules, right? To see what the breadth of our thinking is, what the breadth of application to different fact patterns happens to be. So that we, and you don't have to use many details from cases, but it really helps to get your group who's working with the same rule to be just generally on the same page. All right, it's effective. And if you've done that, then you're building a better decision, right? You're building a stronger decision in this way. All right, and then the last one is that whether it's arbitrary or capricious. Most of us are not arbitrary and capricious. There is, I will simply say this, we all have triggers of some kind. It took me a long time to professionally figure out what my triggers were. It happens to be unfairness. If there is something that seems incredibly unfair to me happening at a faculty meeting, I have to breathe deeply and count to 10 a lot, so that I don't say really awful things, right, about the character of the person who's doing something very unfair. I have to focus on the action, not the person, right? So principles over personalities, we see how all of this works. And the arbitrary capricious thing, though, is often a reaction by an administrative decision maker based on the situation, all right? We have experiences, we have things that we really can move very fast towards. And if we do that without questioning it, right, we can end up making a very weak decision. All right, and it doesn't mean that it was necessarily the wrong outcome. It means that the decision itself is indefensible the way you made it. So you just have to make it a different way. All right, does that make sense? All right, with that. All right, so before I move slides, any questions on this? Any questions on this? No, we're good? We're good? Okay, all right, to the next slide. All right, so here's for standards of review, here's the terrible trio they've got. Clearly erroneous, arbitrary, capricious, and abuse of discretion. All right, the courts are not consistent in distinguishing these three things from each other, so there is sliding between them. But this is the constellation of mean things that can be said about your decision. Okay, this is what they'll say. So what you're really looking at here is whether or not there's a rational basis and facts in the record to support what you're saying. All right, so that means there's two things sitting here, right? That burden issue, right, is present, right? Do we actually have evidence in the record? The second one, though, is really interesting. Rational basis, all right, rational basis. This is very problematic, right? This is because no one can exactly define what a rational basis is. It is a reason. Is it a reason for making your decision? Does it have to be a good reason for making your decision? Does it have to be a logical reason for making a decision? Does your conclusion actually have to work like a philosophical syllogism, like a proof? If this is true and this is true, then the outcome must be true. Therefore, you violated whatever the provision happens to be, right? How tight does the connection happen to be? Different courts treat it differently, right? Some of them, it's any reason, right? With the exception of one. Who knows the one reason that can never legally be used as a rationale? There's one reason. Does anybody know? Do you know the word animus? What does the word animus mean? If someone could raise their hand for that. Animus. Yeah.
Hateful?
It's hatred. It's hatred. Yeah. So we're familiar with the root because we use the word animosity, right? When people have animosity for each other, there's hatred between people. The animus cannot be used as a rational basis for a decision. All right. Hatred of a person or a group cannot be used. This is actually the fundamental legal piece of the puzzle in almost all of the LGBT civil rights litigation by the court. The court has avoided telling us whether we have a suspect class. It has avoided actually determining things based on equal protection or on due process, substantive due process. It talks about them a great deal, but it decides everything on a failure of rational basis review because animus, hatred of the group, was the reason for the law or whatever it happens to be. All right, that is the one thing that cannot be used as a rational basis for something. The interesting thing, though, is that at the administrative level, they're all over the board on how tight the connection has to be for your reasoning. All right, so, and that means deferential standards will tend to work in the favor of the administrative law judge in whether a reason is justifiable or not, right, that's there. So some of these things begin to interact. Substantial evidence is also very interesting because we have a really great thing. So in Washington, this is our preferred standard. This is not the national standard, all right? Different jurisdictions, it's a different standard. But for us, it's substantial evidence. And Washington's preferred standard does this. Ambiguity goes in your favor, all right? Ambiguity goes in your favor. But we have to ask ourselves, okay, what is ambiguity? Right? What is ambiguity? And ambiguity is when things can go either way, like ambidextrous. Right? Ambiguity is something that can be interpreted in at least a couple of different ways. If that's the case, the court will actually defer to you. All right? They'll defer to your reading of it if it's capable of at least two reasonable interpretations. All right? So deference works for you here. And then we talked about de novo also. But the de novo review is triggered by the courts automatically in two circumstances: when there's an error of law, when the actual law that's applied is in question, and for constitutional issues related to it. All right, those immediately trigger de novo review. There's no deference to our decisions or anything we say when those are the issues that are being challenged. All right, any questions there? That one. No, we're good? Okay. All right, institutional deference. These are actually coming out of the federal level, but they make their way into the states. And they're two different deferential standards, and they're kind of interesting for us. So one is the Chevron standard, and the other is the Skidmore. It's called the Skidmore deference or the Christensen deference. The Chevron standard is what happens when you have a formal decision. All right, so some of us work for agencies or departments who will go down on very minute levels, right? So for instance, when people are building things, when we deny permits or things like that, this is, things can be sent out. If they're challenging the denial of something, then we're at a very minute level, right? It's really how high their building was, whether they are far enough from water, right, in what they're doing, or how close they are to the street, things like that. What will happen is that when your actions are formal, right, then they're treated like a legal action, right, with sort of full force and effect of law. Your decision has that sort of legal weight behind it. And at that level, they'll actually sort of defer to what it is that you are doing because you have the expertise and you've given the decision, right? And they tend to want that to stand. So institutionally, what they don't want to do is be incredibly inefficient. Right? They don't want to be inefficient. So if you're moving, right, in a correct way and in a formal way, they will tend to defer to what it is you do and not question how it is you're interpreting your regulations, for instance. All right, they'll sort of allow you to do that. The second one, though, is less deferential. It's the Skidmore standard, and this is where you're moving informally to something. And they look to see whether you've done a thorough investigation. So this is where there's a little backseat driving by the court going on, right? They're going to see whether you're looking left and right and seeing everything that there is to be seen, right, in the case. They're going to take a look at what your reasoning is like. They're going to take a look at, over time, what the opinions of your colleagues have been on the exact same thing. All right, they will actually look for that level of conformity or norming in what your agency or department is doing. And then they're going to take a look at whether this is supported by other agency powers, right? Which is to say, whether the implementation is consistent with the way the whole department or agency is actually applying its rules and regulations and policies. So they look for sort of systematic cohesion in what's happening. All right, and if you know that, right, if you know that in advance, then that allows you to take a look at your situation and make sure that you are conforming, right? You're part of that one. So these standards will work for you if you've done all these things. If you haven't, then there's no deference. There's no deference. All right, so in drafting the decision, let's take a look at drafting for a second. So these are the things that the statute said had to be there. All right, so the finding of fact has to be there, the conclusions of law have to be there, legal reasoning needs to be there, and you've got to have a disposition that discusses its finality and what the appeals process is going to be effective. All right, so this has to be there, and these are the things that meet the constitutional standard, right? If these are there, now you'll notice that every agency department has a different form or way of writing all of these things, right? This is the common forms are difficult because agencies do different jobs. And decision makers have different ways of sort of trying to organize, but these categorically will be what's there. There are other procedural necessities and sort of traditional conventions that go into how we do our decisions. So if you see language like, therefore it is hereby ordered that, right, or it is determined that this is the sanction, and suddenly things are capitalized. We've got a word in the middle of a sentence that just gets capitalized. Order gets capitalized, all right? That's a legal convention. Why the hell that's the case, I don't know. But it's the practice of law, and we've been doing that sort of thing at every level of judicial decision-making for a very, very long time. You look at things from 1890, and that weird capitalization is in there. I suspect that an intellectual historian will say it's actually related to medieval writing, right, of some kind. But it's been around for a while. We haven't gotten rid of it. There's really no typographical reason why it should be there, but it is a matter of legal convention. So every department has legal conventions. It's good to look at, if you're new, it's very good to look at orders that your peers and colleagues have done to see what the conventions in your unit happen to be, and then just conform to those conventions. The court has lots of conventions around this front. There's a very interesting thing that there was a convention I didn't even realize was a convention. Does anyone know Kelly Corr? He's an attorney in Seattle. He's been around for a long time. He's just super, super Irish. He has a really great St. Patrick's Day party, and he's the only attorney that I know in the state of Washington who is allowed to do things in green pen with the court. And it's very, very interesting. He got a variance. I don't know how he got a variance. I think it's by strategic invitation of the parties, but it's a convention, right? We don't usually sign in pink, right, or green or other colors, right? Blue or black, that's the convention. Right, when we're doing it. The margins and spacing, these sorts of conventions, right, are enforced over time. With the digital world, right, appellate margins don't make any sense, right? The 3 inches on one side and 2 on the other. And you've got a little column in the middle. How does this make any sense? But conventionally, that's the way we do it, because that's what print used to do. So we have replicated conventions, and now you're a part of replicating conventions. So this is the cultural history of the practice of law, right, or these sorts of things. All right, the next question is that if those are the things that have to be in there, how do we structure our decisions? And so my suggestion to you is reverse engineer, right? Figure out where you're going with everything, right? And then structure your decision from the outcome. Now, let me speak candidly.
about the writing process. So I think I've been teaching at Seattle U and UW for 10 or 11 years now. And nobody I teach has the same writing process. And when I work with the court clerk and commissioner, the judges, the other law clerks, nobody had the same writing process. But people had similar writing processes. So here's one of the differences. And you can sort of figure out where you might fall in the spectrum. Some people work out their decision by writing everything down. All right, so these are very process people. All right, that we either have to talk about it or we have to write it. Due to confidentiality, we're not really going to talk about it very much. So we're probably going to write it. And in the writing process, we actually make the connections. We figure out which evidence is more important than other evidence. We figure out what the logical links between things are. We figure out what the outcome ought to be. And we wouldn't get there if we didn't sort of move through the whole mess, right, in a given way. Other people are sort of on the other end of the spectrum from this, and they like to do things kind of in one shot. They would like to do something that looks more like the final version than like pre-writing on something. And so those people tend to outline. They'll figure out sort of here's issue 1, issue 2, issue 3. Here's evidence under issue, here's the rules, here's the evidence, here's sort of the arguments back and forth, here are my thoughts on that. And they'll move it through in a really systematic sort of way. And then they'll begin to write it out more narratively, right? Once they've outlined sort of what's happening. The first group, once they've sort of written through the mess, they may do an after-the-fact outline. Now I've seen everywhere I've gone, I can prioritize what's the important parts in what I've said. And then I'll distill out from that. And so they write big, and then they make it concise, right? The other side starts very concisely and then begins to make it bigger. They build it out. Either approach is perfectly effective, right? Either approach is perfectly effective. What I want you to think about, though, is that when you're in the revision process, all right, so now I'm making a distinction between when you're just drafting and when you're actually getting into what's looking more and more like your final decision. When you're in the revision process, then I think it's really important that the revision process be guided by the end results, all right? Because the defendant, the department, whoever is in charge of sort of its final agency review, the court system, if they take review, this document that you're writing it needs to be tight, all right? It needs to be very tight. And what you're making is actually a piece of persuasive writing. Now, it's a piece of persuasive writing in a very interesting way because it's written in a very objective tone, right? That, of course, if this is the law and these are the facts, this is how it applies to the facts and this is the outcome, right? And the system of law has great integrity attached to it. So it has to be the neutral decision maker making their neutral decision in objective ways. So the tone is very, very objective. What's actually happening in the writing is you're being highly persuasive. You're actually building support for your outcome, for the decision you're making, and you're articulating the rationale for it. If that's what you're doing, then your end result is the tightest piece of control you can have on your writing. It tells you, right, it limits you to what really needs to be in there and what connections have to be made to support the outcome. So starting with the end is where I'm going to recommend you start. One of the things that we can look at for the end is that we've got a couple different endpoints we can look at, right? One of them is your disposition, right? What is the actual answer to the legal question in the case administratively, right? Just administratively, what's happening? Is it a sanction that's occurring at that point? The next one you could do is a legal ruling or legal conclusions, and these are a little more qualitative, right? Less secretarial, more qualitative in what's happening, right? Issue by issue by issue. You could start with those, or you can go all the way and look at all of the things we've talked about for judicial review. Where are the things that make your writing weak, right? What is it that the court could attack to reverse? And keep those things in mind when you're writing, right? So there's a lot of different endpoints you can look at, but these are the three big ones that you can do. Any questions on that? Any questions on that? Yes?
What do you do if you weren't quite sure what you want to decide? What would be your best option?
Right, excellent question. So what do you do if you're not sure what it is you want to decide? All right, so I'm going to venture a guess that you're one of the process people.
Actually, I do it this way most of the time.
Oh, okay, all right.
It doesn't
But sometimes you don't know what your answer is supposed to be. Okay, no, that's excellent. All right, so if mostly you do outline and reverse engineer, but sometimes you don't know what the right decision is, then you're actually going to have to use the technique that the other side employs. All right, you're going to have to work through the process of it, just to see what you can find. Right, what are all the pieces of evidence that are there? What's the breadth of interpretation? How has this been applied in the past? You take a look at it. And I will empathize with you because we just had a hearing where the case was weak. The case was very weak for academic misconduct, and but it barely squeaked by preponderance of evidence. Barely squeaked by preponderance of evidence. So the way we look at it then is there is a violation of the student code. But then we get to sentencing, right? What is the sanction going to be? Well, we're looking at this and we're trying to figure out how on earth to approach a sanction when we're not super certain that the violation actually was intentional on this. And so the Faculty Appeals Board is like an appellate board. There's 3 hearing officers attached to it. So they have a discussion, and the discussion is to do a very light sanction, but find a determination that the sanction is warranted. There's a lot of argument about whether that's a correct approach to take or not. The very interesting thing is that let me make a distinction. So a lot of decision makers can be divided into 2 camps. All right, so the world is not truly in a binary opposition, but it sure makes it easier to understand dynamics, right? So but in decision makers, it's kind of fascinating because you can have sort of jurisprudence on one side, and you can have results-oriented people on the other. And the truth is that the vast majority of decision makers, judges and ALJs and hearing officers, are results-oriented people rather than jurisprudence. So a jurisprudence takes a look at whatever is happening in front of them without actually really necessarily needing to acknowledge or empathize with the parties themselves or the fact pattern, right? They will not be swayed sort of by the fairness of a situation. They won't be swayed by the marginality of a situation. They won't be swayed by the various vulnerabilities that are sitting there. What they want is a cohesive legal system, right? Where sanctions are consistent, where the rule is consistently applied. And if there's a defect in the rule, that should be handled at the legislative level, not at the decision maker level. So you don't compromise the rule in order to get a result that seems a little more fitted to the situation. So there are people who emphasize the rule. It's a principles first approach. And there are a lot of decision makers that's how they approach it. But a principled approach to the application of law can have harsh results from time to time. Not always, but from time to time, harsh results, right? The extreme cases can seem harsh. Results-oriented, right? You will, in fact, sort of bend the margins of a rule, play in gray areas, work it, kind of figure out how facts can be used to justify a narrower reading rather than a broader reading, right? Or something like that, in order for the result to actually make sense in the context. When you get to the higher appellate levels, the results-oriented people create great conflicts within the law itself. Okay, our Supreme Court has a tendency to have a number of cases that appear analytically to be in conflict with each other, but you understand the result that they got. But then attorneys have to debate about what the rule of law is from the 3 cases that don't seem to agree with each other, right? And so and that tells you that it's a results-oriented sort of decision. Now, there is no right or wrongness on what kind of decision maker you are. It's just a tendency that you will have. All right. The situation I was describing is where the panel is looking at it, and actually they understand that if you have violated the code of conduct, then the sanction is, right, suspension, academic probation, suspension. There's a grouping of sanctions that can be there. But the people who have that sort of fairness as a driving thing inside of them take a look at that and say, well, without sentencing guidelines or standards, any of these are possible. We're going to select this one because it fits the context in a more fair way. All right, so jurisprudence will pull their hair out at that point, right? And the results-oriented people will say, let's move on. That's the right choice in that particular case. All right, but this is a struggle you will all have, right? Everybody who makes decisions, you encounter that exact scenario, right? Where the sanctions sometimes do not, the situation just doesn't seem like the sanctions should be what gets applied in that area. So then you have to decide whether to do it or not. I remember working with Judge Zilli with the Western District, and he told parties once that he disagreed with the law, and he didn't think it was at all fair or appropriate the way it played out in this case, but he had to comply with the law as a trial judge, and they were welcome to appeal it, and he would be very supportive in that appeal. And if it came back to him, he would be more than willing to follow whatever the appellate recommendation might be, which is telegraphing a loss to the parties right at that level. But that's how he handled that. He's actually more of a jurisprudential person, but he does have a lot of concerns for fairness. And that's the way he built it in. And I've actually seen administrative law decisions where the language in it, I mean, normally we try and paint a very small target, right? Just what you need and nothing else. But sometimes an editorial comment comes in, right, about the situation at hand. And it's very interesting. Sometimes it's not that you've decided against somebody, it's how you've treated them that makes the difference, right? And we see that in medical malpractice cases, for instance. And when we're training lawyers for client relations, we use a lot of information that comes out of the medical field. And one of the things that happens there is that if there's sort of a relationship of trust or respect, you've spent a little more time with somebody, you've spoken a little more directly with somebody, you've used their name, right? You've created sort of a human relation. The desire to sort of react against you for a negative determination is heavily undermined, right? They're actually kind of okay if they've had a fair shake at it, and if they understand why you went in the direction that you did, and you acknowledge where they are and they're thinking about it, or what they did that was right or strong, right? They'll actually be okay with the decision. Now, you will have obstreperous people who, if you decide against them, will argue it as far as they can go. All right, and they'll use the full appellate chain, and if they've got the money, they'll take it into court and things like that. But most people are not that way. Most people are in conflict, and when the conflict resolves, they want a fair outcome, even if they're on the negative end of the outcome. But transparency in that outcome, the human connection, that actually is good for them. We don't normally build the human connection into writing, but we do it during hearings, right, where you're treating people respectfully, being very calm or very kind, asking questions or soliciting information, right? Those are the ways that you prepare the groundwork for the written decision, right? And I think that's kind of helpful. If you're in a case where you can't figure out which way to go, you'll have to work the process a lot until you can figure out where it goes over that one spot, and then reverse engineer. All right, that was a very long answer to your very concise question. Okay, so let me move here then. Where to start? So here are just concerns that we'll have. What's the legal issue? What are the key facts? What's the procedural history? What are the legal rules? How does it apply, the law apply to the facts of the case? What are your conclusions? What's your disposition? This is generally the order in which the ideas appear in any administrative decision. In fact, in any judicial decision, this is the order in which the information appears. And I think everybody is very familiar with this. There shouldn't be a lot of question as to what the legal issue is, or the procedural history, or the rules that are going to apply. The key facts, the application of law to fact, the conclusions you're drawing from it, these are the things that get messy, right? These are the things that are of most concern to the defendant in front of you. And these are the things that are of most concern to the state agency or department or the government, right, talking to you. Those are the parts that they're very concerned with. And that's because that's where most of the decision is happening, but it's framed by the call of the legal question, right? And if we can get the narrowest framing of the legal question, we can have the most concise decision. So sometimes agencies or departments will frame a legal issue a little broadly. And sometimes pro se claimants will frame things very broadly. So sometimes it's up to us to reframe a little bit to make sure that we're getting a good formation on what the issue happens to be. Now, when we look at just what our task is, the real task is simply this. Your job is to resolve the case. We're a dispute resolution mechanism. You are agents of dispute resolution, Resolution of a case is the fundamental thing that you're doing. So some of us are overloaded in this, right? Some of us have an amazing amount of cases or hearings that we have to go through. Some of it comes and goes. There are waves of time, right? And that are either a lot of cases, a heavy volume, or a lighter load. Some agencies or departments, this happens more and more at the federal level, loan their ALJs and hearing officers to other agencies and departments when there's an overlap in expertise. Right, they'll actually combine resources. Sometimes when agencies or departments do not have enough funding, they will join forces with other agencies or departments to sort of help in resolving cases. Regardless of whether you're from a centralized decision-making group, right, or whether you're from a more localized decision-making group, resolution is the name of the game, right, for what you're doing. My caveat to you is to, if that's what you're doing, then to insulate your decision, make it really good and really strong, so it's not challenged, right? And so now we'll take a look at techniques for doing this. So we have 45 minutes, and I'm switching into the writing portion of this. All right, so what we've discussed right now in the first part of it is the larger dynamics and the sort of restraints, the rules, principles, regulations that are there, the concerns for your decision. Now, in getting into the actual work product itself, these are the things I want to talk about. So they're going to be statements in your decisions. All right, and actually, let me ask, do we need to take a break now, or do we go right through? We're going right through. All right, so. Yes, right. Gird your loins. Here we go. All right. Statement of issues. All right. So you're setting out what the legal question is. The control of the question will limit how broad your decision is going to be. The statement of facts is going to split in two. There are procedural facts, right, and then there's the facts that are the things in dispute between the parties, whatever those might be. Now, here's the deal. There are facts, and then there are facts. Right, so all facts are not created equal. Facts can be thought of as being sort of necessary for background. So background facts can be very important for what's happening. There are dispositive facts, right, and those are the facts that are used primarily in the legal test that's being applied, whatever that happens to be. If that fact spins in a test for application, that's a dispositive fact. It's a legally significant fact is another way of phrasing that. You can also have emotionally significant facts, and those are there for persuasion purposes, for fairness purposes, to sort of build your decision in a slightly more holistic way. A lot of decisions don't use emotionally significant facts. All right, they don't. They'll stay away from them, and they'll use background, and they'll use legally significant facts. But there are three kinds of facts. Then there is that we use. The fourth kind of fact is the irrelevant fact that is neither background, right, nor legally significant, nor emotionally significant. And there's often a huge amount of evidence that comes in that arrives in that fourth category. All right, so we need to move the fourth category off the table in our writing and focus on the other three categories, primarily background and dispositive. All right, then you're going to have a statement of legal conclusions. All right, so that's the answer to the questions that are being asked, right? You've got legal issues. For every legal issue, you have a legal conclusion. It is a 1-to-1 ratio on that. Make sure you hit that. Sometimes when you're moving fast, you can miss, right? Making sure there's an exact correlation of 1-to-1 between them. The legal reasoning, all right, the statement of legal reasoning, otherwise known as the body of the opinion. Right? This is where you're making all of the logical connections. And this is actually the part that's required by due process. You have to articulate the justification for your decision, and this is where you're doing it. The second part then, to that is the disposition, sort of as a matter of administration, how this turns out, whether the order is final or not, if there's an appellate process, where that goes. So you have to give that due process information to them as well. When we get into the statement of legal reasoning a little later, I'm going to talk to you about that assertion and justification part. All right, so here's the tone and style. Our tone is objective. Now, I will say that, and I'm not alone in this, many legal practitioners We really like dissents in cases because they're so sarcastic and pithy, right? It is refreshing to have somebody say, you know, there's only one point at issue here, and boy, those people are idiots. Here's how it should have gone, and they just lay it right out. All right, this is, okay, so it's a little rude professionally to do that, but it is very entertaining to read, all right? So there's a lot of different tones. Now, one of the things that happens with that is that the majority is under different burdens than a dissent is. The majority is the rule of law, it's the law of the land. It has to, from a systems approach, present itself neutrally and objectively. It cannot have the luxury of indulging in snarky remarks, right? It can't do that. The dissent, however, is under no such restriction. It can be as snarky as it likes to be. It can leave out massive parts of contrary reasoning or logic, whereas the majority actually has to somehow address them in a reasonable way and say why they are not as compelling as the other side happens to be, all right? Now, for us, we're on the objective side, right? We don't have the luxury of just sort of shooting from the hip. We actually have to have that neutral objective tone, which means we have to handle sort of arguments and counter arguments. Now, most of us don't put in the counter arguments, all right? Most of us don't put in the counter arguments. We say what the significant facts are, we tie them to our conclusions of law, and we get out as fast as possible. All right, now that is unsatisfying to a person who loses in your decision, because what it basically does is it leaves out their significant arguments, and most of the time there's at least some ground to stand on for a dispute, right? Now, some of the time there's no ground, right? It is just it's just a violation, plain and simple, and we really should not be here having a contested hearing. But a lot of the times it is a contested hearing and there's something to contest. It's not the winning argument and it's not the dispositive argument, but there's something to be said for it. So I'm not advocating that you put in handling counter arguments, but there's a lot of judicial opinion writing that handles counter arguments very, very succinctly and puts them in relation to the argument that the court or the decision maker is actually privileging or preferencing, right? The one that they prefer and why. Now, the interesting thing is that if we put that information in, it gives a broader side of a barn to aim at, right? If there's a problem that goes wrong. It provides more information than less, and maybe that can cause a problem. But the interesting thing is that under constitutional standards, we're in the rationale part of your decision. And in the rationale part, right, if you think back to what the triple threat against us happened to be, right there, clearly erroneous, arbitrary, capricious, and abuse of discretion, you don't violate that if you say you have carefully weighed the arguments. You're not violating that. They're not going to find your decision weak because you actually discussed why one line of argument was more effective in the application of the law than the other one was in the outcome. All right, so even though it looks like it gives more cannon fodder to a challenge of some kind, it's not actually threatening from the judicial review perspective. So it may increase the possibility of having a challenge, but it does not increase the possibility of being reversed. All right, does that make sense? Okay, a little counterintuitive, but this is true. I think in terms of client relations with the agency or the departments or relations with the citizenry of the state of Washington, there's a lot to be said for being balanced and acknowledging people and sort of what it is that they're doing. It's not common practice in administrative decisions, but it's possible practice. And it does increase sort of satisfaction with what's happening. All right, and frequently what this also can do is it stops future litigation from people using losing arguments. All right, if you have a very litigious person challenging agencies and departments all the time, frequently they make the same damn argument over and over and over again in various circumstances. This is one of the ways that you stop them from doing that, right? You telegraph what a failed argument looks like, all right? So there's some long-term benefits in future cases as well. All right, are there any questions? No? All right, so let's get back here then. All right, the clear, concise, and cogent. This is, there was some interesting writing training that went on in the 90s and early 2000s, where this was their sort of battle cry, be clear, concise, and cogent. The interesting debate, right, is that clarity is often sort of premised upon the understandability of the language you're using. All right, so the plain English then is preferred, right? Unless you have a term of art or there's something very technical that needs to be addressed, try and use plain English when you're writing. Simpler sentences are generally preferred to complex ones, right? Dependent clauses can send people down a road of misunderstanding depending on how tightly they're reading or how effective their grammar training has been. All right, and since schools no longer officially teach grammar and punctuation, we are going to see an increase in confusion on complex grammar, right? And so, but having gone through law schools, right, everybody actually has a fairly good understanding of, you know, what grammar and punctuation needs to actually look like. And so, but people we're working with don't necessarily have that understanding. All right, concision is interesting, and I think concision is generally misunderstood. So, and here's the general misunderstanding. Concision means short. All right, concision doesn't mean short. It's nice when it's short. We all love it when it's short. Short is awesome for everybody involved. But concision is actually only saying what needs to be said and then not saying anything beyond that. So some of our decision writing will be very, very concise, but look long. All right, it will be concise, but look long. The trick for us as authors is to have concision as a goal, right? To really just try and do it in as sort of precise and confined and narrow way as we can, and not overstate things. Don't add lots of digressions. Don't do anything. Just keep it really, really focused. But do what needs to be done. And so never really worry about the ultimate length of your decision. Worry about whether the decision is concise or not, where only what needs to be there is there. All right, so that's what concision means. Cogent, right, means that it's logical, reasonable, understandable, right? That it actually has to make sense to the reader, all right? And this can get very interesting the longer that we are in service to the state, or the longer we are in service with a particular department or agency. We forget how complex things are. We forget how strange this will look to other people. And we dwell in that, and we automatically just begin to work at that level of complexity. And that may make things look not very cogent or very clear to an outsider because they're not seeing the connections that you're making. All right, they don't know what else has happened in the agency prior to that. They don't know what 12 years of enforcement has looked like, right, on this. But you do, so you just automatically begin to reel that out. And so just be a little cautious, right? And one of the ways to be cautious is to simply use the reader as your guidepost. How will a reader, right, an intelligent but a non-legal reader respond to what it is you're saying? Will they understand what it is you're saying? And if you think they don't when you draft it, then you simply revise it to make it slightly more understandable. All right, so it's a goal. It's not an absolute rule, but it's a goal to do that. And it's something that's really accomplished on revision a lot of the time. All right, so organizational signals. This is one of the most effective techniques in our writing to make sure that the reader understands what we're saying. All right, organizational signals. So this is headings, roadmaps, and signposts. Let me speak briefly about these. Are people familiar with like the Chicago Manual of Style or the NLA guide or things like that? This is generally speaking. All right. Anyone who's kind of made it through university setting has encountered these tomes, either with delight or annoyance, depending on your relationship to the organization. But what happens with them is they both have different ways of articulating structure in writing and making sure that the structure is signaled to the reader. So headings become the easiest thing for any reader to see. And I want to, actually, let me look here for a second. Yes, there we are. Okay, so I'm gonna go to this slide for a second and chat about this. So there's an area of study called cognitive physiology. And does anybody know what cognitive physiology is? It's a fun combination of ridiculously weird words. It's how we think based on our physical bodies, how the brain is structured, how the eyes work, how the ears work, how your mouth works, things like that. So the impact that the physical body has on our cognitive ability, our ability to think. The interesting thing in English is that our eyes are trained in a very particular way for encountering information. All right, and one of the interesting things is that it mirrors a little bit how our ears work. So our ears hear sound, but if the sound is undifferentiated, if there's a constant buzz or something like that, it's not intelligible to us or our brains. We refer to it only as a buzz, right? If you start to break it up, the buzz might actually turn out to be Morse code. Right? But it's the breaks between the sound that begin to tell us what's meaningful about what it is that we're hearing. Words are this way, language is this way, because in English, words are articulated differently. And we speak in units of words. We can distinguish between words. When I pause, there is a gap in sound coming from my mouth, so you know when my sentence has ended. Right? This is when we listen to songs, right? You know the difference between songs because there's a gap between them. You know the difference between notes because there's a change in information. A note goes up or down, right? It gets louder or softer, right? This is the change, right? Scientists will call the rate of change the delta, right? The change is actually super significant to our cognition, how we think and how we interpret information. Visually, what this means is that our eyes are also trained towards a physical experience of information. They move very rapidly in something called a saccade. And a saccade, so your eye is not this perfect pivot. It doesn't move very smoothly from one side of the room to the other. What it does is it moves in fits and starts. It does this, right? And that's how eyes work, all right? So ophthalmologists learn this very early in their training. The impact of that on writing is fascinating. It means that your eye moves very quickly through blank space, all right? And it stops, the saccade, it stops when it encounters information, something dense. It sees something. It only interprets that something when another space appears. So the spaces between words are important to us when we're reading, right? The punctuation and the differentiation between sentences is important to us when we're reading, and the way paragraphs have blocks of information that then change is important to how we read that information, how we encounter that information, what's understandable or intelligible from that information. Headings are these awesome things that work with the physicality, right, of our eyes and how that works with cognition. So headings will occur after a large blank space, right? There's going to be a gap before the heading occurs above it. There's going to be a gap before it. There's going to be a gap after it, right, on one side, and there'll be a gap below it. So your eye is going to see this as a complete chunk of information, right? Now, when it sees it as a complete chunk of information, your brain gets very delighted because it's going to interpret this chunk of information. And when your brain interprets it, it needs to be somewhat understandable. So there are a couple of different kinds of headings, all right? There's a topical heading and there's an argumentative heading. In law, these are the two that there are other headings, but those are mostly the headings that we use. Do you know the difference between the two? What is a topical heading? What is a topical heading? This is, yeah.
It discusses what the issue is going to be that you're going to have.
Yeah, so it puts the issue out there, the topic, the subject matter of whatever that organization of writing is going to be. It names it. It provides a name. That's a topical heading. An argumentative heading is slightly different. What is an argumentative heading? What's an argumentative heading? Do people know? Do I give it a shot? No. Do we have a colleague who will have that?
It's when you lay out your argument, it's going to be in the paragraph below it.
Yeah, it makes a point. An argumentative heading is a heading that makes a point. So frequently you can kind of think about an argumentative heading as something that looks like a conclusion, right? It asserts a position on something, right? Now the interesting thing for us is that if we're very interested in efficiency in writing, the topical heading alerts any reader to what's going to happen in this huge set of paragraphs that follow it. Okay, but the reader doesn't know what actually is happening in those paragraphs. It just knows that if it wants to find out, it goes there to that section. All right. If it's an argumentative heading, what the reader now understands is actually how the whole thing in that section turns out. So when they read it, they're reading it for justification. They want to know why it turns out this way. right? Now, if you have a reading audience that is skimming, they're gonna read heading to heading to heading to heading. All right, we all do this. You're doing it because in terms of cognitive physiology, that's what your eye wants to do. And that's what your brain wants to do because that's the easiest moment of understanding. So if you're doing persuasive writing and you're wanting to have a tight, efficient piece of writing, a topical heading isn't as efficient as an argumentative heading because the reader has to drop deeper into it to get to the information they want. An argumentative heading will actually give them everything concisely as if they're reading an outline, right? As if they're reading an outline. And that's very efficient for information comprehension, all right? So one of the first pieces of advice then is use headings and use them effectively, all right? And I'm simply explaining to you why they're very, very effective. Now, there are some caveats to headings, which are kind of interesting. All right, one of the caveats to headings is that it's sometimes referred to as the one breath rule. Have you ever heard of the one breath rule? I love the one breath rule, right? So some people sub-vocalize when they read, right? They're sort of saying the sentence that they're reading. And we do this with headings a lot because it's big and bold and we find them. And so we sort of read it, now we're done. Right, and we figure out what it says. The one breath rule says that if you can't read it by the time you take one breath, you will run out of oxygen for your brain, and your reader is not going to comprehend very effectively what it was you were trying to say in the first place. So if you move towards an argumentative heading, you're going to have to keep it somewhat short. All right, one breath. No longer than one breath if you were to read it in a sub-vocalized kind of way. Otherwise, your reader doesn't have the oxygen to get through it, all right? And when we're writing the argumentative headings, then usually that means keeping it less than 2.5 lines. Usually a breath will get you about 2.5 lines through. 1 line is great, 2 lines is okay, 2.5 lines, if you really have to do it, don't go above 3. Right, and so this is why, if you've ever been trained for sort of why headings look the way they do, they may not have discussed it, but this is one of the reasons, right? Because the reader reception to the information is limited by the amount of information that's there. Dense information is harder to comprehend, right? This is also one of the reasons why people bury things in the middle of paragraphs, all right? Because you won't see them there very easily, all right? But let me move back. Actually, I'll do this. I'll go to the second one. All right, so positions of emphasis then, in cognitive physiology, positions of emphasis are very, very important. And in English, we're actually trained to read from left to right, from top to bottom. All right, so our scanning goes like this, right? And this is how typewriters were constructed. Typewriters are constructed because of how we approach language and written language in English, right? It's very tailored to our culture. The way computers put their information out is exactly the way English likes to see words and information put on the screen, even if you're coding and the code is no longer English. It's a programming language, but it's going to roll out, right, as the same sort of structure that English is using. What that means is that the first and last positions are the most important. And again, this is cognitive physiology. The eye moves quickly until it encounters information. Then it slows down. Then when the information stops, when the sound stops, when the word stops, when the sentence stops, when the paragraph stops, right, it goes fast through the white space again. Your brain has then, the first thing it encounters gets priority, it gets emphasis. The last thing it encounters before it jumps into a space, right? This is like, you will understand the ground you're running on when you start to run and when you jump off the cliff, right? You know exactly what the ground felt like. This is the way reading works, right? The first and the last things. This means that in formal English writing, and decision writing is as formal English writing as we get, really, in our particular culture. When you've got formal English writing, the structure of first and last is emphasized, all right? An introduction, a conclusion, right? In a given section, so that's the large scale, right? If you want to understand a piece of critical writing, you'll read the first part of it and you'll read the last part of it to see how they're setting it up, what they're answering, and then how it all ended, right? And then you may read in the middle if you've got time, right? The way a section will work is your first and last paragraph can be read by the reader. The reader could actually skip from one to the other, and they should be able to get what it is that you're saying. right, by reading the first and the last thing. But we're going to do that at every level of organization. Our brains and eyes simply work this way. So we will read first and last paragraphs, and cognitively they will have a point of emphasis. We will read first and last sections, they will have a point of emphasis. In a paragraph, we will read the first and last sentences. They will have cognitive emphasis in our brains. And in a sentence, the first and last parts of the sentence have a point of emphasis. All right, and that's just how human beings in English, right, will encounter the written word. So our technique then is to simply strategically use the fact that we emphasize the first and last. Whatever is most important, we want to begin with, and whatever is second most important, we want to end with. All right, and whatever is least important goes in the middle. All right, it somehow goes in the middle. Now that can be used and abused, right, in any number of ways. But this is part of why we bury things in the middle, right? Is because that's the way our brains actually are working with perception. The second one is the second point here then is to use topic sentences, right? So if you're in a paragraph, right, and you use a topic sentence, that topic sentence is going to tell the reader what the point of that paragraph is, what's happening in that paragraph. All right, and if you do that, that one sentence will be emphasized to the reader. They will understand what the point of the paragraph is. Then they can delve in, if they need to delve into kind of what's happening there. The conclusions are very interesting because it's very nice to then wrap up the paragraph or the section with a concise summary or what the outcome happens to be, because that will be emphasized in the reader's mind also. You can use those conclusions to help guide you in your headings, right? You can use the conclusion of a section to help guide you in drafting your heading, because your heading can be a very short version of whatever your conclusion happens to be, right? This way, parts of your writing are starting to resonate with each other. It is very tight organization when the headings and conclusions all correspond with each other. When the topic sentences allow a reader to understand exactly what's happening, section by section or paragraph by paragraph through what you've written. Now let me go back to this slide. Things that help us with this from a reader's perspective, right? So now we're being very reader-centered. I heard we had a federal judge at the law school who referred to this as readerly. If we are readerly in our writing, right? We're readerly. Then what we're giving them is not only headings, but we're actually giving them roadmaps to what we're saying. So roadmaps, CLU is awesome in their legal writing program for the emphasis on roadmaps in critical writing. And the emphasis on roadmaps is simply this: you tell the reader what's coming up, all right? What the different things are that they're going to be encountering. Right? For instance, you might say that violation of a certain regulation is dependent on 3 factors, 1, 2, and 3. You list them out. That list is a roadmap. The reader understands that what's about to come is you're walking through those 3 factors. All right? And if you've got that sentence in there, the reader can say, I'm not concerned with factor 1, I'm really concerned with factor 2. And then they will jump to factor 2. All right, but your roadmap, and it begins to enable them to do that. The third piece of the puzzle here is the signposts. And signposts are language inside paragraphs at the beginning of sentences that because it's a position of emphasis at the beginning of sentences, it lets the reader see that that's where the information is coming. So if you have a list that is a first, second, third sort of list, you want to use signals, right, as signposts that use the word first. First this. Second that, and third this, right? And then when they skim, they can see it, right? They can see it. So the roadmap sets it up, right? The heading tells you the topic, the roadmap sets it up, the signposts let them know where they are along the way. It's a narrative GPS, all right? That's just a good way to think about it. It's a narrative GPS. So these are things that can help us in our writing. It's particularly helpful in the rationale section where you're doing the legal reasoning that's supporting your conclusions of law. Because that's where it gets messy. That's what requires the most organization. All right, so then we've talked about that. So let's go here. This is the very interesting thing that I began to encounter when I was working with attorneys and judges from around the world. That legal system, legal reasoning, legal thinking, and legal decisions fundamentally relied on this formulation, assertion followed by justification. Right? This was the most consistent structure to any judicial decision. Assertion followed by justification. So what that means for us is how do we handle assertion and justification? So if you start with a conclusion, right? Because persuasive writing will often say, all right, let's start with the end result and then we will show you how we got to the end result. So here's the end result. Now I'm going to show you the justification. As we move through the justification, the one word I want you to pay attention to is the word because. Because is the most powerful sort of legal, logical connector we've got in our language. Because tells the reader that you are about to encounter the justification. All right, it telegraphs to them very clearly, concisely, and cogently, justification is about to follow. All right, and they can find your reasoning. They can find your reasoning. This is helpful for your departments and agencies. It's helpful for citizens. It's helpful for reviewing courts if they see what your justification happens to be. All right, and remember that there's standards for you, right? The three nasty things they can say about our writing, right, is going to actually look to see whether we have justifications. And if you signal it very, very clearly, it's an easy decision for them to support what it is you have said. All right, it makes it very easy for people. So the word because then is something that should go in any analytic section where you're actually explaining what justifies your outcome. All right, use the word because. It makes it very simple for the reader. All right, I want to talk about this briefly, the passive versus active voice. So I'm assuming that people know the difference between active and passive voice, but I've got to ask because never make an assumption on this level. So what is active voice? We'll start with active voice. What is active voice? Now we're testing your school grammar training. What is active voice? Say that again.
I listen to Theo.
Yes, I listen to Theo. Well, you listen to Theo. All right, so it's Mike. All right, so Mike has said, I listen to Theo. So Mike is the subject of the sentence. He's the actor of the sentence. The verb then is listen, right? And then there's an object of some kind or an indirect object, in this case, to Theo. So Mike performs the action, listening is the action. To Theo, I'm the indirect object of this action. All right, if I were to flip that into a passive construction, we'll just take that same sentence. What's a passive construction of that sentence? Yeah.
Theo was listened to by me.
All right, Theo was listened to by me or by Mike, right? This is so now the object or indirect object becomes the subject of the sentence, right? Now, how grammatically confusing is that? Right? It's a very strange thing to do to a subject of a sentence. It's not the actor of the sentence anymore. Something in the predicate of the sentence, came over and took over the subject. The verb had to switch around, and we ended up with a longer sentence. All right, so this is the difficulty with passive voice. Passive voice is usually longer, and it is definitely grammatically more confusing. All right, and one of the reasons it's slightly more confusing is because the emphasis just goes all wonky. All right, the indirect object hits the place of privilege in the sentence, right? So that sentence now emphasizes me up here rather than the listener, right? Who's actually sort of performing the action. Listening actually is in the ears of the beholder, right? So it's a strange sentence in that way. Now, passive voice, however, is also very strategic because if you want to confuse your reader, so now we're going to be readerly, but we're going to be sneaky about it or cagey about it, the passive voice becomes our friend, and it becomes our friend in a very particular circumstance. We want to, right, sort of hide agency. If we want to hide agency, passive voice is wonderful because the predicate of a sentence becomes the subject, and the actor of the subject just can go away a lot of the time. All right, so if you have an active sentence that says, say Mary bought a coffee, we know who did it, we know what was done, and we know what was purchased. It's a very nice, concise sentence in very few words, tells us a lot of information. If we say the coffee was purchased,
we have no frigging idea what happened, right? This is, people buy coffee all the time. We don't know who the actor was in this, right? And if it's a fact that's important to us, right, then the actor of the action becomes important. It's also, yes, you have a question.
Just in our context,
Yeah.
my favorite example is we deny the petition versus the petition is denied.
Yeah, okay, so that's very conventional language, right? So these are sentences that are part of legal convention and tradition, right? The petition is denied, right, versus we deny the petition. All right, now that's something where the lengths are not all that different, but we may be playing with emphasis, right? What it is you want to emphasize. Now, my favorite example, and I just love this example, is Ronald Reagan during the Iran-Contra affair, right? This is, so does anyone remember his sentence? Best use of passive voice in American politics ever. Yeah, mistakes were made. Okay. Yes, they were. That is true. We are very interested, however, in who made those mistakes. And also in what they were exactly, right? So that is a genius use of passive voice. It obscures agency. All right. Now defense attorneys know this in criminal settings because it is a lot nicer to say somebody was killed at 9:05 in the evening in their home than my client killed them. Right? So here we don't like active voice as a defense attorney. We want to obscure agency because we're debating agency. So now passive voice is my friend. So the thing about passive voice is that it is a damn effective tool in persuasive writing. But you want to know why you're using it. You just want to know why you're using it, and you want to use it to the correct intended effect, right? And usually that's because you want to obscure agency of some way, or you want the emphasis to change. You want to put the emphasis on something else. So you're either obscuring agency or you're using a creative way of changing emphasis to not the subject, right? Not the actor. You want to put the emphasis on what's acted upon. These are very good reasons to use passive voice. Virtually any other reason is a bad reason to use passive voice because your sentences can get very, very long. Now, logically, right, if our fundamental structure for judicial persuasive writing is assertion followed by justification, if you're writing a sentence that obscures agency, you are not helping the reader establish the connection between your idea and the outcome. All right, you're just not helping them in that regard. So it becomes less effective as a tool unless it's for a very particular point or purpose. Does that make sense? Okay, so then let's take a look at this. All right, proximity in writing matters. So we're at a sentence level. All right, so now we're talking about sentence level in our writing, and we just want to move the subject and the verb to be close to each other. All right, we want to move them close to each other. There's a very good reason for this, right? Because the reader their eyes are scanning through, and the positions of privilege are active for their cognition of what it is they're saying. When you hit a verb in a sentence, you know you have changed gears in the sentence, right? That is a change in the quality of information that the reader is taking in. We often just wait through the subject of a sentence or all the introductory clauses until we hear the verb. And then when we hear the verb, we know what's happening in the sentence, all right? Is there anybody here who speaks German? All right, a few people. Is there anyone here who studied German? There we are. All right, there's more people who tried to study German than tried to speak it. There's a reason for this, because in German, the verbs go at the end. This is very difficult for a very skilled or focused English speaker. We're very, very used to cognitively knowing what's happening verbally in a sentence, the action of a sentence, before we get to the end of it, right? Now, the German grammar with the verb at the end means that that verb at the end can change a lot of what you thought that sentence was doing. So telephone conversations get very fascinating, right? But in English, the verb is really one of the most powerful things you've got. So sometimes the verbs are so strong that we actually turn them into nouns. Those are called gerunds, right? So for instance, in a simple way, if you say, if swim is your verb, right?
But you really want to emphasize the idea of to swim. You can say swimming is important. Right, now it's the subject of a sentence. We've turned a verb into a noun, but we're doing it for emphasis reasons because we want us all to focus on how important swimming is. All right, so but now we're going to say something about swimming and we're going to employ a different verb, right? So, and whatever that may be depends on what it is you're trying to say. Here's the interesting thing for subject and verbs being close for the reader is that the reader can make the bridge much more simply if they're in proximity. So I'm at the University of Washington. A great number of our graduate programs and departments pride themselves on being able to write one-sentence paragraphs. Right? This is the mark of true education in erudition, is the ability to write a one-sentence paragraph. All right? Legally, that is horrifying. It's just horrifying because there's just so much that can go wrong for the reader during that very long sentence. So much misunderstanding can happen. So much misemphasis can happen. So we tend to write in much more concise, tight, shorter sentences. And we try and keep subjects and verbs close together because it keeps control of the reader. It limits the reader's ability to go astray in what it is that we're saying. So rather than have a compound sentence, split it into two sentences. Or if you really need to join them, use a semicolon, right? And say, well, this is one unit, but we're treating it like two effectively independent sentences. They're all one sentence, right? There's ways to do this, but you want to sort of keep the subjects and verbs close together. The interesting thing for us is that the structure of the sentence conveys the reasoning, all right? The actor and the action and the object of the action is actually a logical connection for the reader, all right? It makes your case for you. If your grammar gets in the way of that very simple operation, you're undermining the ability of your decision to be effective, all right? So my advice then is to sort of follow these suggestions. All right, there's a couple of other things to be aware of at the sentence level. One of them is being verbs. So I'm just going to assume that everybody is far away from grammar and punctuation training. I know I generally am, but I'm a wonk. I wouldn't be teaching school, so I just love this sort of thing. I find it very funny or interesting. There is a difference between a helping verb or an auxiliary verb and a being verb. So, and it simply is this. A being verb is the verb to be in all of its various guises, right? Is, was, were, are, right? That's the were being, right? All those sorts of things. Auxiliary helping verbs are when you see those verbs, but they're attached to another verb. And it usually is what happens when you get a progressive tense, right? So we were discussing opinion drafting at today's meeting. All right, we're discussing, the were is a being verb, but it's helping or auxiliary to discussing. It's not actually the verb in the sentence. But if I say, the defendant is liable, all right, all I've done is create a giant equal sign. Defendant equals liable. I have not explained anything about the reasoning justifying that commission at all. All right, so there has got to be a better, so if I make a sentence that uses just a pure being verb, all I've done is make the subject equivalent to the predicate. That's it. That's all I've done. No logical structure or advantage has been given in that sentence. So I'm going to have a second sentence to explain it, right? I'll need a second sentence to explain it. And then that's not efficient writing. I'm no longer being concise at that level. So focus on what it is you're actually trying to say. Now, I will say this very clearly. In the drafting process, we will all use being verbs massively, all right? If you ever just free write or begin to write things out, if you're one of those messy process people, half of your sentences are going to be you saying, this is that, and then this is this other thing, and that was this way, and then it might have been like that, and you sort of do all this writing. But that's for you, that's shorthand because your brain is starting to associate these ideas with each other. That's what a being verb does. It associates ideas. It associates the ideas. The step in opinion writing that ups the level of practice is when you haven't just associated them, you're actually explaining the connection between the ideas. And that's explaining your rationale, your reasoning, all right? So what you are is in search of a verb. You're in search of an active verb. You will get it, right, in your drafting, but as a process, we often first equate them before we fill in the connection. That's just part of our thinking as we work through. So allow the thinking to happen. Don't be shy about that. But on revision, right, work that out. Get the being verbs, at least as many of them as you can out. All right, and then the sort of last point I have here is minimize the use of nominalizations, like that sentence, actually, nominalizations. So so here's the, I'm sorry, sometimes I like to be a little cheeky in what I'm doing, but so it's nominalizations when you turn a word into a noun. All right, so one of my favorite ones as a state employee is maybe about 10 years ago, a word made its way into virtually every presentation or panel discussion or convention that I'd gone to, which was impactfulness. It's like, okay, what the hell word is impactfulness, right? This is, something has an impact, right? This is impactfulness. Nominalization is actually something where you see German's impact on Old English, because German very quickly turns a lot of words into nouns, right? It is very adept at doing that. And in English, we can do that too. The problem is, when you use nominalizations, it gets needlessly complicated. All right, needlessly complicated. You end up with a word that is, okay, so nominalizations are multi-syllable words by necessity, right? You can use a much shorter, plainer word to say what it is that you're trying to say. All right, and the reader, it will be more readerly, right, for your audience encountering it if they understand clearly what it is you're trying to say. Nominalizations tend to take place for a lot of different reasons. My favorite one at the university level is when people want to sound very smart. They use a lot of them, but they're not necessary. The people with more experience practicing law or their various disciplines, they actually tend to communicate much more clearly and concisely. They leave the nominalizations and they just say more plainly what it is that they mean. All right, and that is actually very well received by a reader. Very well received by a reader. It's much clearer to the reader if you just go for the common word that people use. All right, that is the presentation I have for you today. I'm simply going to leave you with this winking George Washington and a couple of caveats. You can contact me at Myhre, so T-M-Y-H-R-E at uw.edu. I'm happy to talk with all of you. The other thing is that if you're in an agency, I'm really going to sort of suggest that people work together, right? That cooperation on understanding the structures, the different decisions or opinions people have, really help one another understand what your group is doing. And when you're writing, all right, if you're having a struggle, it is way better to ask for clarification or assistance from behind-the-scenes people than it is to have a defective opinion. All right, so err on the side of caution, right? And you've got lots of experienced people around you that are very willing to give you the benefit of their experience and what it is that they know. And I'll share with you what experience I have, paltry though it may be. But it's always a pleasure to talk with you. So thank you for inviting me.